All right, we are green. Welcome back, my brothers and sisters. I am Braden. This is Langley Outdoors, the place where we not only talk about what's going on in the gun world, our beautiful country, how we're going to fix both of those things together. Guys, the SCOTUS finally got off their butts. They kicked us in the balls, and then they said, wait a minute, here's some ice because there's something else coming. This one is going to be interesting because the big Snopes case that we've been waiting on for 11 different weeks now from the SCOTUS has been denied grant for certiorari. Now, the interesting thing about this is, yeah, that happened, but what they said afterwards, it's going to make you at least scratch your head. Everything will be linked in the description box below. I can't wait to hear what you guys think, and of course, make sure you hit that like button, subscribe to the channel, and turn the notification bell on, because guys, this is the stuff that we are actively fighting for our rights every single day, and we will not quit even when we get kicked right in the proverbial balls. All right, let's get into this. I want to show you something I'm super excited about. We have dropped a new limited time design, and it's so apropos for today. We are coming for our rights. Uncle Sam is pissed. We the people are pissed. This is the limited time design available in black and in navy. This is meant to fulfill the promise of what we do shirts on. We wear what we believe, and believe me, we're coming for our rights. This month, we're going to dive into the suppressor removal from the NFA. After that, we're going to go after concealed carry reciprocity nationally. After that, we're going to keep on pushing to get SCOTUS to do what they said they're going to do. This shirt is literally wearing what you believe, and to me, it looks amazing because Uncle Sam looks pissed, and I know you guys are too. There's a link in the description box below. This will be available through Friday, so make sure you check that out. The first order's in or the first one's out, and it'll be perfect time for July 4th. All right. Let's jump into the actual situation. Again, everything is linked. Sorry, Katie just texted me right then. All right, here we go. If you guys are not following me on X at Braden LOA, I have all of this cited there for you. You guys can check out the links. You can check out the conversation, see the comments, jump in, join the conversation right over there at Braden LOA. But here's everything broken down. So this is pretty much the vibe that we've got so far on this across the board. Holy crap, this is a massive loss. I kind of disagree on the sentiment that this is a massive loss. I'm going to show you why, but it's not good. Don't get me wrong. Don't get it twisted. I'm not out here banging the drum for SCOTUS. This is crap. However, it's not necessarily a massive loss because I want to show you what they actually said in these documents because that's where the key is. My buddy over at Washington Gun Law, Bill, said, F. SCOTUS denied both Snope and Ocean State petitions. A great day for those of you who want you disarmed. This is all the unnatural emotional reaction. The Supreme Court, this is from the Second Amendment Foundation, has denied SAS petition for certain Snope v. Brown, our challenge to the Maryland assault weapons case. I'm going to read all these dissents, so that part doesn't matter. However, I want to show you this part right here. This is from a guy who has been following this really closely. Quote, "Don't kill yourselves, guys. All hope is not lost. Kavanaugh concurrence," basically, because there's two things that you guys need to know on this. Kavanaugh came in and he wrote we're not going to take it, but he said some things which you're going to need to know about. And then Justice Thomas came out and said, well, this is some bullshit. All right. The interesting part about this is the Thomas part is expected. But what Kavanaugh said is he basically gave a timeline. And he said it's going to happen, just not this case. Again, I'm not a fan of this. I want them to take this one. I'm just telling you objectively what they said because it's rare that they would say that. But anyway, here we go. There's another one from News 2A. Supreme Court order today denied petitions for writs of certiorari in the cases of Snope and the Nicholson. This is a quote from Thomas. Quote, "The Fourth Circuit erred by requiring the challengers to prove that the Second Amendment protects their right to own AR-15s, or, in the terms of our Second Amendment jurisprudence, that their conduct falls outside the historical exceptions to the right to keep and bear arms. Justice Alito and Gorsuch issued separate statements. Alito and Gorsuch would grant the petition for a writ of certiorari. The majority, Roberts, Sotomayor, Kagan, Barrett, Brown, and Jackson, denied the petition for certiorari." Now, if this was all you got, this would be annoying as hell. And it would be bad news, and it'd be the worst thing ever and really irritating. However, when I jump into this, Kavanaugh's statement on the Snope denial published, reading it now, I'm floored. It's from Hannah Hill. She's affiliated with National Association for Gun Rights. I'm going to read that to you in a second because that is where some interesting stuff pops, okay? I'm going to keep on going. Kavanaugh, some highlights. Since millions own ARs, there are strong arguments the Fourth Circuit got it wrong. Okay, that's a knock in the positive. Okay, again, Let me just keep on going. I'm going to tie all this together in a second. I'm just showing you what's up. Again, from Costas Moros, the optimistic answer is they were negotiating behind the scenes and decided they didn't want the issue now, but agreed to take a future case soon, Kavanaugh's statement. Basically, the pessimistic answer, and this is a good summation, is they are spineless and they will never meaningfully enforce Bruin. So here's the basically pros and cons here. They either being pessimistic view of they're never going to do anything, or the optimistic view of they said they're doing another case in the next term. I don't know which one that is, but that's what they said here, and I'm going to read the document in a second. Hannah Hill, again, it's a bad day for the Second Amendment. This punt was unnecessary, and the reasons given ring hollow. The hope does too, honestly. Now, she's representing the pessimistic view. Again, I'm going to show you all of this, and then Gun Owners of America is representing the optimistic on this tweet. Supreme Court declines to hear cases challenging assault weapons bans and magazine limits, but Justice Kavanaugh gives gun owners some hope with this statement. Again, I'm going to read the whole thing. This court should and presumably will address the AR-15 issue soon in the next term or two. Now, are they going to? I can't tell you that, but Kavanaugh did say that in the statement, and that's one of the things that I want to highlight here as I'm reading this to you. You've got two different viewpoints here. There's a lot of things that are beneficial in what Thomas put in here in his dissenting, and then there's some time frame related things that Kavanaugh put in here. Again, this is all flowing out as of this morning, about an hour ago. So when you look at this on its face, it's annoying as hell that they didn't accept or didn't grant cert for the Snope's case. However, what they're saying, the reason why, is interesting. Let's get into this. Again, I cannot tell you what they're thinking. I'm just telling you what they did. So this one right here is from Kavanaugh. This is the part that they were mentioning in earlier post. The petition for a writ of certiorari is denied. Justice Alito and Justice Gorsuch would grant petition for writ of certiorari. This is the Snope's case. In District Columbia of Heller, this court ruled that the Second Amendment must be interpreted in light of the constitutional text, history, and tradition. The court further determined that the Second Amendment protects those weapons that are in common use by law-abiding citizens. Again, it doesn't sound like a dissent at this point. It sounds like, no kidding, this is a no-brainer. Because handguns are in common use by law-abiding citizens, the court held that the District of Columbia's ban on handguns violated the Second Amendment. The court's later Second Amendment decisions in Bruin and Rahimi did not disturb the historically based common use test with respect to the possession of particular weapons. Again, this is reading like AR-15 bans are unconstitutional because common use. Here's all the historical precedent. But again, they didn't take it. Let me keep reading. This case primarily concerns Maryland's ban on AR-15s and a semi-automatic rifle. Americans today possess an estimated 20 to 30 million AR-15s, and AR-15s are legal in 41 of the 50 states. So this is an important piece to this. They just hit common use 8 different times, really 3. But then they go in and they say there's 20 to 30 million of them AR-15s, and they liken it to the Heller decision, which is a handgun common use test. Well, what are we doing here? Why are we saying no then? Okay, let's keep on going. And of course, it highlights the fact that 9 states are behind the tyranny blanket. Maryland that prohibit AR-15s are something of an outlier. See these? The AR-15s traditionally have been widely accepted as lawful possessions. Given that millions of Americans own AR-15s and that a significant majority of the states allow possession of those rifles, petitioners, wait for it, have a strong argument that AR-15s are in common use by law-abiding citizens and therefore protected by the Second Amendment under Heller. If they have a strong argument that AR-15s are in common use, which has been alluded to in the introduction there multiple times, why are we not taking this case? Again, wait until the end of the sentence or the paragraphs here. Where did I go? Here we go. If so, then the Fourth Circuit would have erred by holding that Maryland's ban on AR-15s complies with the Second Amendment. This whole thing is reading as AR-15 bans are unconstitutional. So you have this is the important piece. You have a lot of text from Kavanaugh here that says none of this makes sense for a banning of the rights. But then at the same time, they denied cert. So something else is going on here. And again, I'm not going to sit up here and bang the drum and say, oh, we're amazing, we're incredible, 4D chess. I don't like the 4D chess stuff. However, something doesn't jive if you're hitting common use 800 times with basically supplementing the laws of common, or the perception of common use, and then not granting cert. Something doesn't jive there. Let's continue though. Under this court's Second Amendment precedent, however, it can be analytically difficult to distinguish the AR-15s at issue here from the handguns at issue in Heller. AR-15s are semi-automatic, but so too are most handguns. Again, this is just why. Law-abiding citizens use both AR-15s and handguns for a variety of lawful purposes, including self-defense in the home. For their part, criminals use both AR-15s and handguns, as well as a variety of other lawful weapons and products in unlawful ways that threaten public safety. But handguns can be more easily carried and concealed than rifles, and handguns, not rifles, are used in the vast majority of murders and other violent crimes that individuals commit with guns in America. Again, this is reading like AWBs are illegal. Let's continue. In short, under the court's precedents, the Fourth Circuit's decision is questionable. Again, this is still Kavanaugh. We're not to Thomas yet. Although the court today denies certiorari, a denial of certiorari does not mean that the court agrees with the lower court decision or that the issue is not worthy of review. The AR-15 issue was recently decided by the First Circuit and is currently being considered by several other court of appeals. Right here, this is the piece where Kavanaugh is basically laying out the groundwork here. Because again, I'm not doing the 4D chess thing. I'm just telling you, I'm reading this as it is. Opinions from the other Court of Appeals should assist this court's ultimate decision-making on the AR-15 issue. Additional petitions for certiorari will likely be before the court shortly, and in my view, this court should and presumably will address the AR-15 issue soon in the next term or two. Let me translate that out for you. He just spent 2 pages explaining why AR-15 bans are unconstitutional and ARs fall under the common use test in Heller. And then we're not going to take the case. However, there are multiple other cases in the appeals level of which will help the SCOTUS break into this issue more clearly, and then sets a time frame of the next term or two. You know what that means? That means they want all the appeals court cases to go through, and they want to get final judgment on those appeal cases to let it percolate more, and then they say we'll have enough. Now, if you believe that or if you don't believe that, I can't affect that for you guys. But I can tell you, that's what that says. Let's go to Thomas, because Thomas was cooking with gas too. All right. Here's Thomas and his dissenting. Justice Thomas dissenting from the denial of certiorari, the state of Maryland prohibits ownership of AR-15s, the most popular civilian rifle in America. This petition presents the question whether the ban is consistent with the Second Amendment. The Fourth Circuit held that it is reasoning the AR-15s are not arms protected by the Second Amendment, which is incredibly stupid. I would grant certiorari to review this surprising conclusion. Again, this is not reading like, yeah, no, it's fine. This is reading like, let me cook. That's what this is reading like, at least to me. But you guys can let me know what you think. I'm not doing the 4D chess thing. The Second Amendment guarantees the right of the people to keep and bear arms. When raising a Second Amendment challenge, an individual has the initial burden of showing that the Second Amendment's plain text covers his conduct. That's in the Braden decision. Once a challenger makes that showing, the Constitution presumably protects his conduct, and the burden shifts to the government to demonstrate that its regulation is consistent with this nation's historical tradition of firearm regulation. See that Braden tie-in? If the government fails to make that showing, the restriction must be deemed unconstitutional. This part. It is difficult to see how Maryland's categorical prohibition on AR-15s passes muster under this framework. To start, AR-15s are clearly arms under the Second Amendment's plain text. There's Heller, there's Rahimi, there's Braden, all of this. And it's all linked if you want to read this entire thing, because I'm not going to read all of Thomas's portions here. But you have to understand, all of this is not reading like the fatal complete, the world is ending. It's reading like this. Don't kill yourself, guys. All hope is not lost. It's reading like the Gunners of America post. What they basically just did was they said, we're going to go ahead and let this cook a little bit further, and then we're going to take this up in the next term or two. I'm not okay with the way that they went down on this. I'm not okay with them denying cert on this. It's stupid. It's obvious. Their own concurring and dissenting opinions right there just did the entire case for them. Yet, they've punted it down the road. That's where we're at on this. So, guys, spread this out. I hope I illustrated what they were doing here. I was trying my very best to just read the actual decisions and give you a lay of the land. Let me know what you think in the comments field. Follow me at Braden LOA, and make sure you pick up these limited time designs, because they are not going to be here forever. Right there's a link in the description, because damn it, we are coming for our rights, and even stupid, mealy-mouthed, weak-willed SCOTUS justices are not going to stop us. Everything will be linked in the description box below. I will see you on the next one. So much is popping. Stay free. See you later.